Assalamualaikum warahmatullahi wabarakatuh. My name is Nadia Binti Pambi and my metric number is 1192225.
My name is Nur Aina Sofia binti A. Aziz. My metric number is 1192242.
Amira Farisa binti Zulkarnain, matrix number 1192261.
Table of contents. Number 1, the problem statement, which give definition and the answer for the problem statement. Number 2, knowledge. What happened if there is no force majeure clause, the essential of invoking, and the importance of force majeure clause. The third one is the practical steps. It tells us how and when the force majeure clause can be enforced. And the last one is the conclusion of force majeure clause. Problem statement. Definition and the answers for the problem statement.
Assalamualaikum warahmatullahi wabarakatuh. Inshallah, today we will present to you our written assignment with the problem statement. Are force majeure clause applicable in COVID-19 pandemic? What is force majeure? In general, force majeure refers to unforeseeable occurrences or situations that prohibit or prevent someone from carrying out a task. Force majeure must be explicitly stated in the contract in Malaysia, and such clauses are commonly seen in manufacturing, supply, services, and construction contracts. A force majeure clause from a contractual perspective is it gives a party a temporary relief from completing its contract obligations when a force majeure event occurs. A force majeure clause usually specifies particular circumstances or occurrences that would qualify as force majeure events, as well as the conditions that must be met in order for the force majeure clause to apply to the contract. The occurrence of such events must be beyond the parties' control, and the parties must demonstrate that they have made reasonable efforts to reduce the impact of the force majeure event. What if the case is in scope of force majeure clause? If an incident or circumstance falls within the event and meets the clause condition for applicability, the parties will be excused from performing their respective responsibilities under the contract for the duration of the force majeure event. Depending on the languages of the provision, the parties may be required to provide a written notice informing the other party of the occurrence of such event and invocation of the force majeure provision. Some contracts additionally state that if a force majeure incident lasts for an extended period of time, the parties may be able to terminate the contract. Are force majeure clause applicable in COVID-19? The construction and language of the force majeure clause in the contract are the deciding factors in assessing if COVID-19 qualifies as a force majeure event. According to the law, an agreement must be understood according to the wording used in the agreement. The COVID-19 pandemic may fall into this category and qualify as a force majeure event if the force majeure clause clearly specifies disease, outbreak, or global health emergency as force majeure event. COVID-19, at the very least, qualifies as a force majeure event under the definition of events beyond the control of the parties, because the parties have no influence over the incident, spread, or imposition of the movement control order by the government. This is the evidence that we found. When someone has entered into an agreement or contract, the parties need to fulfill their obligation. According to Section 38 of Contract Act 1950, the obligation of parties must be performed to the contracts. And additional information in Indian statutes, it is mentioned in Section 56 of the Indian Contract Act 1872, which state that an agreement to perform an act that is impossible in and of itself is void, and a contract that becomes impossible or unlawful to perform after it is entered becomes void in law due to an intervening occurrence. In the Indian case of Halliburton Offshore Services Inc. versus Vedanta Ltd. and UNT, the parties were involved in the integrated development of various blocks in Rajasthan before the Delhi High Court. The petitioner requested a 1-week delay on the invocation of bank guarantees following the release of the lockout. claiming that the work would have been performed regardless of the lockdown. The appeal was rejected on the grounds that it was an afterthought and that multiple reminders had been sent since 2019. On behalf of Vedanta Ltd, it was argued that an injunction against the invocation of a bank warranty could only be issued in the event of substantial fraud. After careful consideration, the court took a liberal stance and granted an ad interim injunction in favor of Halliburton Offshore Services, Inc., finding that the COVID-19 epidemic and lockdown were prima facie force majeure events beyond any party's control. As a result, the application of the force majeure exception varies from case to case, while a court can give equitable relief such as temporary injunctions establishing the standard for force majeure.
Next, the knowledge. It tells us what happens if there is no force majeure clause, the essential of invoking, and the importance of force majeure clause.
What happens if there is no force majeure clause in contract? First and foremost, the contracting parties can apply Doctrine of Frustration. Doctrine of Frustration is a contract that is frustrated when an event or situation is uncontrollable or anticipated and has caused the contracting parties to be unable to perform their responsibilities. According to Section 57, Subsection 2 of Contract Act 1950, a contract to perform an act which, after the contract has been made, becomes impossible, or by reason of an event which cannot be prevented by the undertaker, is invalid, will be void when the act becomes impossible or invalid. Secondly, the contracting parties can refer with a qualified attorney. Refer to an attorney to go over the terms and conditions of the contract agreement one by one. If the contracting party agrees to consider, the new agreement terms and conditions must be recorded in writing. This new agreement must be written in order to ensure that the rights of the contracting parties are protected, and also seek professional advice from an attorney to guarantee that their rights are preserved in the future. Before applying force majeure clause, the contracting parties must know that their contract will be void and unenforceable. The contracting party invokes force majeure when unexpected events occur throughout the terms of the contract. The contract will be ex facie and unenforceable when a circumstance changes dramatically or beyond the contractual party's expectation. Ex facie is a legal term commonly used to note that the explicit terminology of the document is flawed without the need for further research. If the contracting party wishes to continue the agreement, they can do so after the situation has returned to normal. The event shall be unavoidable and unforeseeable situations. The event that unavoidable and entirely beyond their control, giving the contracting parties no option except to deal with the incident. In fact, even a dramatic increase or decrease in the value of a currency and price has no effect on the contractual agreement. In other words, the burden is not a necessary consideration. Instead, the inability to fulfill the contract responsibilities is the essential condition for applying the force majeure clause. Next, the contracting parties must fulfill the specific requirement of force majeure clause. The current situation or event can be characterized as a force majeure occurrence under the contract's force majeure clause. It is very important to choose the words that can be used in the contract so that the situation or event that occurred can be classified under it. To determine the situation or event that occurred can be classified as a force majeure clause or not are the words used in the contract.
So, I will continue the presentation on the importance of force majeure clause. First and foremost, force majeure clause could give the contracting parties the flexibility and also the freedom to decide the terms of their contract. Besides, it also to preserve the contract and the company's interest, which means that the parties can uphold the contract and get temporary reprieve from completing their duties with legal assistance. For instance, if the parties have entered into a long-term contract, they might amend the terms of the agreement. This clause should help to secure the businesses outside there if something unforeseen event happens, such as COVID-19. As for additional information, the people who are already in a contract need to avoid looking for other alternative business arrangement in crisis because it could worsen their own businesses.
Practical steps. It tells us how and when the force majeure clause can be enforced.
Let's move forward to the practical steps to apply force majeure clause. This slide shows us on how and when the force majeure clause can be enforced. Firstly, the parties need to analyze the force majeure clause list of words and the contracts as whole. The terms of force majeure clause is very important in order to carry out during the unforeseen event. Secondly, they need to discover other different ways of performing, reducing delays, and lessening any loss for the other party. For example, find the other supplier even though it is quite costly. Thirdly, any notice that are required under the contract should be delivered as soon as possible and in accordance with the contract's notice requirements. The parties need to take into mind the wording of the clause and the time frames that are required for distribution of notice when deciding what event or scenario you believe qualifies a force majeure event. Okay, let's move. The fourth one, the parties should retain a written record of the reasons for the failure of the performance. And the last one, they need to consider the doctrine of frustration as Aina presented before, if there is no force majeure clause in their agreement. Hence, I can conclude here that firstly, we need to find other initiative first before we apply the force majeure clause. If we can afford it, then we apply the force majeure clause. If there is not enough condition for the parties to apply the force majeure clause, then they can use the doctrine of frustration. Easy, right?
The last one is conclusions of force majeure clause.
In conclusion, all firms should carefully assess whether they or their counterparties will be able to continue to fulfill their contractual commitments and obligations as part of their preparations for managing the effect of the COVID-19 situation. Remember here, the terms of force majeure clause is very important if the parties intended to enter into a contract, as this term can be applied if there is an unforeseen event that occurs during that time. A person that intends to enter into a contract must ensure that the terms of the agreement could benefit both parties.
That's all from our group. Thank you.